Yeah. So hi, I'm Jennifer Kupiszewski of the Untitled and Kupiszewski Law Firm. We have a small law firm in Scottsdale, and this is what we do. It's guardianships and estate planning and conservatorships and probate administration. So this is our world, and we're going to welcome you to our world. In the back, we have a lot of material, so if you forget what I said, have further questions, think of something later, feel free to take that with you. We also have a special needs newsletter that you can sign up for. We send out alerts. Oh, I don't know. You guys hear me?
Not that well.
All right. Oh, is that better? Oh, good. Okay. So we also have a special needs newsletter. We send out alerts, things like recently Social Security. You can report your wages on an app now. There is definitely an app for everything now. Social Security has their own. So we send out things like that in our newsletter. All right, so we're going to start today with the least restrictive option related to someone who may need help making decisions. And this is the powers of attorney. It's the easiest. We're going to talk about ones that you can download online, but these are what we can use to help people make decisions if they need some assistance. All right, so there are several different kinds of powers of attorney. There's the healthcare power of attorney where you nominate an agent. That is, if you are in a coma or you can't, for whatever reason, you're incapacitated, you can't make decisions for yourself, you need somebody to be your agent, to serve in that capacity, to tell doctors, yeah, that's a good procedure, or no, it isn't. Also, in your living will, can express if something catastrophic happens to you, what your wishes may be. So this is a vehicle to allow someone to get HIPAA information and to assist in medical decision making. Mental health care powers of attorney, you will read about pretty much only in Arizona. They are kind of an Arizona unique thing because a general power of attorney is not going to allow someone to put somebody into an inpatient locked psychiatric unit. A mental health power of attorney will nominate an agent to do that should you need it. And so, some people may have some mental health issues that from time to time they are in need of inpatient assistance. Other times people have medication issues that require, where someone's not doing well may require some inpatient assistance. Then there's the financial or durable power of attorney. And those, as they say, are for financial. Financial and durable is the same thing. You'll see them called different things at different times, but they are the same. And it will allow someone to make financial decisions. Now, these are somewhat dangerous documents because they are very ripe for abuse, particularly in our older populations. They can be a vehicle for abusing. But if someone just needs assistance with their finances, this may be a good avenue to do that. All right, so you don't always come to a presentation with lawyers to get something for free, but this is free. You can get your healthcare powers of attorney for free. Download it. It's a wonderful life care planning packet at the Arizona Attorney General's office. You can fill them out and have your own healthcare powers of attorney. I should say that as we're going along, if you have questions, it's way more interesting if you ask questions. So please interrupt me at any time and ask questions. Yes?
Can you go back one slide so I can finish
No, so now you've asked me a question that I actually don't know the answer to. Yes, the answer is yes, I can. I wasn't sure about that until that moment. It's not functioning quite how it should. Yes?
For the financial POA, if I had that for my child, and my child went out and did some crazy business transaction, but I wasn't involved with it, does that get thrown out then? If I say why would you do this? Why would you sign this credit card deal or something like that? You don't have power of attorney. You're not the financial power of attorney. Does it work like that?
Not necessarily.
Contractually.
If you want to speak to that more, because she's our drafter of all powers of attorney.
So unfortunately, it doesn't work that way.
Okay.
So when you become the agent for somebody, it doesn't mean that they're removed. It just means that you also have the authority to help make decisions for them.
Okay.
You may be able to go back and convince the vendor who that person signed up for, whatever they signed up for, that this person shouldn't be making these decisions, that you are the agent, which brings us back to one of the points that Jennifer said at the beginning, which is that the person has to have enough capacity at the beginning in order to sign the power of attorney in the first place. So if they sign it and the next day they go out and sign up for some subscription that costs too much money, it's hard to go back and argue that they didn't have capacity, but they had capacity to sign the power of attorney.
Okay.
If they signed a power of attorney and, a year later they have a traumatic brain injury and now they can't make decisions, those might be arguments you can make. Does that help answer your question?
Okay, does everybody get this down who wanted it?
Or you want us to just try to figure out how to go backwards again?
I just want to watch us do it.
We're better lawyers than technicians.
Oh, yes, I promise. So, supported decision making. We do not have this codified in Arizona law at this point, but it is something that a lot of people are talking about. It looks like a wonderful alternative to full guardianship, which we're going to talk about next, which is very, very restrictive. So when you're looking online, you're seeing it. I mean, people can put together their own supported decision-making teams, but we just don't have anything, say, for example, in the statutes authorizing the Division of Developmental Disabilities to have any system like that in place for their members. But it would be much more in terms of the person's self-reliance, having input, really respectful. But we don't have it yet. But maybe there's a website down there. I'll make sure everybody gets it down before I move on, so I don't have to go back again. But that's a place where you could look into that more. Maybe that's a good fit for your family and you want to try to put that together on your own. Did everybody get this? I can move on? Okay. All right, so now we're going to talk about the most restrictive option, and that is guardianship. And that, of course, is a court action to take away someone's right to make their own decisions. And so this is why it doesn't feel that good, because it is a lawsuit to take away someone's constitutional right to make their own decisions. I mean, when you turn 18, how many here have kids who may be 18?
Not quite yet.
Yeah, I have 5 of them, right? It's terrible when they turn 18 and they know everything. You gotta be kidding me. They weren't any different than the day before, right? But bad decisions, those youthful, immature decisions, that's not guardianship. That's just life, smacking you around until you figure it out. So guardianship is somebody who is not able to make their own choices because it's going to be detrimental to them, that they can't understand the choices. So the guardian makes the decisions like a parent does for a minor. So you can imagine if you were under guardianship, that's a pretty big deal to have your mom at age whatever, 25, 40, right? The guardian acting as your parent telling you what to do. So it's a significant thing to think about. So it basically terminates all of the decision rights of an adult. It can terminate the right to vote. That used to be in Arizona. Sometimes you'll read online some old information. Used to be in the Arizona Constitution that a person under guardianship couldn't vote. That's not true anymore. That has been amended and changed, and so they can retain the right to vote. It's very, very common for someone who has a developmental disability to retain their right to vote because they're probably still in school, and we're hoping they're going to mature and be able to become that full citizen and to be able to participate. Yes?
What about a family that did this years ago when they could not vote, and now is there any way to help so that that person can now vote, or because it was done then?
That's a great question. So the answer is you could go back to the court and ask to have that right restored, and then they would be able to vote. So the question was, if they had an older guardianship and that right was taken away just because that's the way it was in the Constitution at the time, could they get it back? The answer is yes. That leads to another excellent point though, and that is that a guardianship can be flexible and it can change over time. And so you can give people certain rights that they need as they grow and change as you move forward. You have to go back to the court to do it, but it can be done. Also, I'm going to tell you something that only makes sense really if you're a lawyer, and that is that permanent in law doesn't mean permanent. It just means not temporary. Right? I know. What? Okay, that actually is an important distinction because in law, when you look at statutes, if it says temporary, it usually means the judge hasn't heard the full evidence. It means it was done under some sort of extenuating circumstances and it's time limited. That's what temporary means to judges and lawyers. Like, oh, there's there's some limit to whatever this is that we're gonna have to deal with. So permanent means it's been fully heard, everything's done, and you have to go back in order to terminate it, right? So a guardianship can be terminated. Permanent does not mean forever. It does not mean that in law. It just means not temporary. Yes?
I have a person I work with whose mother is a guardian for this young man who's 20-something, 21. She says she has to go and redo it every year.
So that's a great question. You don't redo it every year. The guardian does have some duties and ongoing responsibilities to the court. And so the guardian has to file an annual report of guardian to show the court that it's still necessary, that the person is doing okay. I mean, it's a check-in with the court to make sure that this vulnerable person is all right and that their guardian is, executing their duties. And also they have to affirm that the guardianship is still necessary, because if it's not, it's really the guardian's obligation to say it's not necessary, let's go get this terminated or revoked. That's a good point. And so unless they have mental health authority, which we'll get to, and then you do have to do more each year, because that is, so a guardianship is a constitutional taking of someone's right to make decisions. Mental health authority is a higher interest. It is the taking of someone's liberty as if they were incarcerated. And so it has a higher standard, and it does have to be renewed each year. All right. Okay. So guardianship is based upon someone's incapacity. That's a medical condition. Competence is a different legal concept, and most often in the common speech is a insult. And so people are not, they're under guardianship not because they're incompetent. They have some medical condition that rises to incapacity. So I've been talking about all this. You have to go to court to get a guardianship in the state of Arizona. If you're reading online, there are some states that have a more administrative process. That is not true in the state of Arizona. You have to actually go to the court and do the following things. As the petitioner, being the parent does not make you the guardian when the child turns 18. You're still the parent, but you don't have legal responsibilities anymore, and you don't have any legal rights to that child anymore. So you have to go to the court and say, I want to be the guardian, my child still needs help. I want to continue acting in the same way I have been for the last 18 years, but I need actually the court, you need the court to actually give you legal authority. You have to submit yourself to the jurisdiction of the court, because nobody has to be the guardian. You don't have to do it. No one has to file it. So, how do you talk to courts? This is how you talk to courts. You can't go up and just talk to judges. They don't like it, and they won't talk back to you, because there's a process, and they can't have contact with parties individually. So what you have to do is file a guardianship petition, all right, and that is those are your words to the court to say, hey, we need a guardian, and here's why, and here's who the person is, and here's who I am. And then you have to go to the clerk's counter. We call this petition and all the associated documents with that pleadings. They are pleadings. Pleadings are how people talk to judges. That's how we talk to judges until we actually get in front of them. Yes?
So if you have a child that's like mentally 2 or 3 years old, when would we start that process? If they have a lot of medical issues, is there a way to start it before 18?
Absolutely.
Okay.
So again, I keep mentioning the internet because there's a lot of old information on the internet, and so I was trying to make sure people know when they're looking at something that's outdated. It used to be you could not do that until the child turned 18 because they were not an adult. We have a specific statute now that allows you to file 6 months before the child turns 18, specifically to avoid the need for emergencies or any gap in decision making, so that the order, it can be granted before the child turns 18, but it will be effective on their 18th birthday. So there will be a seamless transition if you did that, in case maybe somebody needs surgery or maybe has regular trips to the ER or something that would create a real need for that. So yes, you can do it sooner. Just a tip, when you go and communicate with the clerk, so the first person you see in court is the clerk's office. You walk in, you get through the metal detector, and there will be a line of windows, and those are the clerks of the court. This is who everything gets filed with. These are the people who make sure you did it correctly. They're also the people who, if you didn't, will tell you and send you back and tell you to try again. They're the people who give you hearings. Be nice to the clerk. They have all the power. So they can send you home with nothing. One thing clerks really, really don't like, and when I'm down in court, I hear it all the time, people are trying to file on their own, is that they filled it out and they went to the clerk's office and they handed it to them. And the clerk said, well, where are your copies? Because I'm keeping this one, right? So where are yours? And the person goes, well, I didn't make copies. And the clerk will say, I don't copy. It's not what I do. And it's very expensive to have the clerk make your copies. So at least one original, because they need original for filing, and then you also need copies for filing. So this is the universe of the packet. There is a packet online that you can look at, that you can actually file on your own. It's in Maricopa County at Maricopa County Superior Court. Just Google that. They have a long website name, but if you just Google Maricopa County Superior Court, they have a great website. It will come right up. They have a little icon, looks like a form, it says court forms. You click on that and you'll see probate and you'll see adult guardianship, and they will have all of the forms online. These are the forms that you will need. Cover sheets. The cover sheet has a lot of very detailed personal information in it. That is held with the clerk and it's not available online. Indeed, none of these are available online. No one can go online and look up your probate matter because you're filing confidentially, physician's report about whatever this person's, medical condition is, and you're giving away your information about how tall you are and your height and your weight and your address. That can't be had online. So when you're filing it, if you were to go online, you can just see the docket and just see what, whether there's hearings or whether there's a case. That's all you can see. So these are the beginning. So there will be a packet 1. This is what you need to get started. This is what the clerk, we talked about the clerk, what the clerk will expect you to have in order for them to be happy enough to take your case and file it in. Then there's some in-between things that you have to do, the physician's report and the notice of hearing. And then when you actually get to the hearing, and yes, there will always be a court hearing, then you have the final papers that you're going to submit to the judge. Throughout this entire process, I cannot emphasize enough, you need copies. Somebody will keep your copies at some point. Okay. Oh, yes.
Are there any provisions for survivorship of a guardianship? Like if the guardian passes on and this person who's the subject that is clearly not competent to care for themselves, what's the process to make sure that that's picked up and moved forward?
Yeah, so there isn't one.
Okay.
So, unfortunately, we don't have a formalized successor guardianship statute where, let's say, the guardian passes away or the guardian becomes incapacitated themselves, right? Then there isn't anyone waiting in the wings. We don't have a sort of trigger for that. You can, as the guardian, put into your will who you want to be the successor guardian, and there is an expedited process for that individual. Sometimes as people are aging or they're thinking about this, it's a good idea to have a co-guardian. And again, you might read old stuff online. We didn't have that until about a couple of years ago, formalized in statute, but you can't have a co-guardian. So if something happens to one guardian, you still have a guardian, and they just notify the court, hey, this guardian can't act anymore for the following reasons. And the guardianship continues, and then that guardian could nominate a successor co-guardian, so you could continue it that way. But we don't have any statute that says if there's something happens to the guardian, this person is next in line. I'm gonna do right back there, and then, yes.
For the co-guardianship, I noticed the forms didn't allow for 2 people to petition at the same time. You do 2 separate forms?
Oh, right, yeah.
2 separate sets?
So to be fair, we don't use the forms because we have our own pleadings.
Right.
I do sometimes look at the forms. They are kind of awkward. You would never do 2 petitions. I was just trying to think through if those were going to be updated. But anyway, you would never do 2 petitions because then you're going to get 2 case numbers.
Right.
And then everybody's going to be confused, and that would not be good. So I think on the forms you could probably just write it in or attach a separate paper, but they may not be updated yet since the statute was updated 2 years ago. I'm not on that committee.
All right.
Oh, I'm sorry.
That's exactly what I was going to ask, but if you were going to do it at the same time at the beginning packet, or if it had to be addendum then, or how you do the co-guardianship.
Yeah, so you're going to want, and you're definitely going to want that co-guardian if you're doing it on your own. to be on that court cover sheet. I mean, they have to have that information, and they've got to do their own affidavit, right? So they've got to do their own the order too, all those things that are required, they've got to do their own setup. So you're definitely going to want them in from day one. It's just on the form, you definitely can attach your own, you can attach your, say, look, here's the first guardian, and then see attached page 2 and write it out yourself. I mean, they're used to people doing things themselves, so it might be awkward, but they'll work it through. It will work itself through, but you definitely want them in the beginning, and you don't want 2 petitions.
What about 2 parents? Would they be listed as co-guardians?
2 parents can be co-guardians if they both agree to be guardians, but they don't have to be. All right, so, and you brought me right to priorities: spouse, adult children, relative caregiver, person's nominee. I mean, those are the priorities for guardianship. That's who we look to first as the natural person to take over that role. I talked about affidavits of appointment. You have to swear that you're a fit and proper person. As I said earlier, just being the parent's not enough anymore, right? So, and if you have significant criminal history involving violent crimes or drugs or any kind of if you're on one of the registries for child or elder abuse, then that may be a reason to deny and find the person's not fit. There will be a court investigator. This is a person employed by the court who will come out and look into these things. Is the guardian needed? Does the person understand a guardianship? Does the guardian understand what they're getting themselves into? And are they a proper person? They file a report with the court, give the court the information. The court takes that very seriously. They're nice people. I don't hear complaints about them. They come out, they listen. One warning I know we always like to give: anything you say to the court investigator, it is not confidential. It will go in that report, and it will go in front of the judge. So you have not nice things to say about your ex-spouse or your sister. Temper it when you're talking to the court investigator, when you express your concerns, because they will say exactly what they called that person up. Yeah, it'll go in there. Don't do that. It doesn't look good. There will be a court-appointed attorney. In Maricopa County, those individuals, they have contracts with the county. If the person is indigent, in other words, they don't have their own income, they don't have their own assets, then their funds are paid for by the county because you are taking away someone's constitutional rights, and they have a right to an attorney. They're all experienced probate attorneys, but they do have to ascertain the person's knowledge of what is going on, the knowledge of the guardianship. So they will need to meet with the proposed incapacitated person on their own. And I know that seems strange in a lot of situations, or that it doesn't make a lot of sense, but they have to at least be able to tell the court, I tried, my client wasn't able to fully understand, and then they will represent whatever the client wants to the best of their ability. So when I was court-appointed counsel, I had a really lovely young man, talked to him about voting. He was in civics, he definitely wanted to vote. Talked about the guardianship, he didn't understand it at all. I said, are you comfortable with your mom? He said, yeah, I am. I love my mom. What would I do without her, basically? Like, what? I don't even know why you're asking me this. And I said, well, what would you really like to see happen? He said, well, I just want to make sure that my Matchbox cars, that nobody moves them out of order. I can represent that. That's fine. That's what I told the judge. She could be the guardian, but don't move his Matchbox cars out of order, okay? So the physician's report. So this is another benefit to filing before 18, because you are still the parent, and so you still have the HIPAA rights that haven't yet transferred to your soon-to-be adult child. And so you can go to the physician, and the report is online in the packet. It's a fill-in-the-blanks kind of form, and you can say to the physician, I would like you to fill this out in support of my guardianship. Do you think a guardianship is needed? It's a great opportunity to start having that conversation. What does the person need? And the physician will fill that out. If you wait until after the person turns 18, then it may or may not be something the doctor is comfortable doing, because the rights in terms of who gets that protected health information will have transferred to the adult, and that's just going to depend on the medical office. So it's definitely easier to get it before they're 18, because you know you're still a parent with rights. Yes?
On this form, there's a spot where it says, when did you last see your patient? And so what's the amount of time from when the doctor last saw the patient filling out the form to go into guardianship.
Right,
Saying
right.
still,
Okay, so, all right, so the question is, there's a spot on the form, it does say that, when did you last see the person and how long is it, if it's too long, is that not going to be valid anymore? Because it is a piece of evidence, right? This is your evidence, this form, you have to file the original, this is the evidence that the person is incapacitated. So I would say if it's more than about 6 months, the court's going to say, I need more current information in order to make a finding today. So if you're going to file, I wouldn't get that done first. You're going to want to do that closer to the time that you're filing. Okay. So guardianship, again, it's a lawsuit, right? So if somebody, hits your car or, something happens, falls at your house, whatever it is, you're entitled to be noticed that there's a lawsuit against you so you can show up and defend, right? This isn't any different. The person who you allege to be incapacitated is entitled to personal service. It is a significant taking of their rights. So they have to be personally served, even if that seems very strange in your situation. Others can be served by mail. Oh, yes, thank you. Oh, no.
On the physician's report, the last point I have, I printed out the PowerPoint. It says that we need incapacity evidence. What does that mean?
So that's your physician's report.
Oh, okay.
That's what that is. The report outlines activities of daily living, where the person should be residing, what their diagnosis is, what medications they're on, what their limits are. So that is your evidence.
And that evidence comes into play for the first time in the physician's report, or are there other forms that we will have filled out and filed that give that kind of information?
So that's a great question. The question is, is the physician's report the only piece of evidence of incapacity? Are there other forms that you need to fill out? Maybe you have an evaluation that's pretty current that you think outlines things better. So if it's an uncontested guardianship, so uncontested means nobody's going to object. Nobody's going to file in and say, this person doesn't need a guardian, or I should be the guardian, they shouldn't, or the person, right, the alleged incapacitated person, your child, shows up and says, I don't want a guardian, I'm 18, and I know everything, right? So if none of those things happen, and it's going along swimmingly, then the physician's report's the only piece of evidence of incapacity that you should need. Could you provide other things to the court? Of course, you certainly can, but there won't be a full trial on the issue, and so it won't be necessary. That should be the one thing that you need. If it is contested, then it looks all different, and that's much messier. All right, your case will be set for a hearing. I outline here sort of the amount of days it typically takes. This helps you with the timing. So, 6 months prior, it's a good time to get started gathering the evidence and looking at the forms, but it's not like you need to file 6 months prior because the court won't get you in. That's not true in the probate court. You will hear in family court, things are set out months and months and months. If any of you have experience with that, that's true. It's not true in the probate divisions. There will be a hearing, and you will have to present some testimony. You're going to testify. If you want to be the guardian, you have to raise your right hand and swear to the court that everything you said in that petition is true, that everything you're telling the court about this individual is true, and that the person needs it. Now, that being said, they are very, very nice. It's an informal setting if it's not contested. It's very nice, informal. Someone will ask questions, and you'll be able to get through it, and the hearings only take about 10-15 minutes. There are some mandatory trainings, and I would suggest that you do these even before you get started, because it really outlines what being a guardian is. These mandatory, they're only about 20 minutes, they're online. I don't know if we have the website on there, but
We do, just
you can't hear.
Is that the website? It's www.azcourts.gov.
Yeah. Yeah, www.azcourts.gov/probate. Also, if you just Google, right, court trainings for Guardianship Arizona, it will come up. So, a lot of don't have any assets, they don't have any income ability, they are going to be applying for SSI. We have some information in the back on applications for SSI. So if that's the case, ask for the fee waiver packet. That's very, very important because the action is being filed for the benefit of the child who's turning 18 who is incapacitated. So it is their income that counts for purposes of the court fees. Everyone is entitled to access to justice, even if they do not have their own money. And so those fees can be waived because that person is indigent. And the fees are fairly significant. It's about $300 for the filing fee, and then another 400 or so, just rough numbers, for the court investigator. Yes?
Now, is that the same process when your child has had SSI as a minor and now they're redetermining evaluation?
So the question was, if you're asking for the fee waiver, if that's the same process as that SSI as a minor. And the answer is it's easier because you'll have that eligibility letter for SSI, which is presumptively means the person is indigent and they will sign the waiver. A lot of people don't have that because they weren't on SSI. But going to the second part that I thought I heard you say was when they have to reapply when they're 18. That has nothing to do with this, but when they turn 18, they will have to apply as an adult for SSI. So there will be a reapplication process.
Okay, because I'm actually going through it with my son right now, and we didn't have to reapply. They just sent us a letter saying it's redetermining, and you're sitting at all different places. Is that the same process?
Yeah, that's the same process. I use a different word, but yeah, they have to go through, because the person has categorically changed, and go through and say, is this person still an eligible person?
Oh, gotcha.
Yeah.
And there's some fees for that?
That's good. So Social Security is completely separate. There's no, I'm not aware of any fees for Social Security, but the fees for the guardianship at the clerk's counter. This is a conversation you're having with the clerk when you first go in. So courts are a pay-to-play system, right? If you want to be involved in the courts, there will be filing fees, and you've got to pay them before they're going to accept your filing unless you get a deferral or waiver. So that's a separate packet. And you can get a deferral or waiver so that you can get in without paying the fees because the person you're doing this for is unable to pay them. So the physician's report is filed as a confidential document. There are instructions in the packet on how to do that filing. So it's not scanned in, it's not available. Even if somebody went down and asked for the hard file, that is protected health information, will not be given out. Guardianship, so you go in and you get an order, you get through the whole hearing, and you've testified after you're so nervous, right? And you leave and you're like, did it? No, you didn't. You're not done. You are not done. Because remember that clerk I keep talking about? Yeah, they're the person who issues your letters. The judge said, hey, I find guardianship is appropriate. I'm going to order that a guardian can be appointed. But remember, you have to submit yourself to the jurisdiction of the court. So you got to take your order that you get. You gotta walk back to the clerk and say, I did it, now make me official. And then your letters will be issued. Those are your walking around papers that you can show to doctors and other people and say this person is under guardianship. That's actually when you've done it, is when you get your letters issued, and that is done by the clerk's office. Oh, and then if you're going to have orders that will be in your packet, send them down 5 days prior. Judges really, really like it if you send them the information and they can look at it and they're prepared for their hearing instead of walking up the day up and being like, here you go. Yes?
You've mentioned a couple of different times having 3 copies of orders. Is there some significance to that number?
So the question was, I said a couple of times you need 3 copies. Is there some significance to that? Yes, because everybody involved in the case is entitled to a copy. So you've got your judge, right, the clerk, you, and your court appointed. So 3 copies, if you have your original and 3, you're covered. So we talked a little bit about this before, mental health powers. They are in the physician's report. They have to be specifically enumerated that the person is likely to need inpatient treatment within the next 12 months, and hospitalization, and they have to be redone every 12 months. You have to go back to the court and say it's still necessary. We talked a little bit about this too, because you guys asked great questions. You can retain the right to vote. The right to drive is something that will be taken away as part of a guardianship, but the person can regain it. They can regain their ability to apply for a driver's license, but they're going to need the physician to either say up front they're still okay to drive, or take some kind of driving course that certifies them as eligible so that NVD is notified and they're able to go forward and get their license. No, that's what I'm saying, from the beginning. She was saying you don't always have to be suspended. The presumption is that it will be, you're gonna have to provide some information from that physician up front if they're not going, if the person's right to drive is not gonna be suspended.
So what if the person doesn't have a license and isn't driving now, but I don't want to preclude him from driving, and neither does his doctor? So would he put in there, still has driving rights even though he doesn't drive now?
Yes, you can.
Okay.
I can tell you, and Emily can speak to this too. I can tell you I've had judges say, well, but can they drive now? They want to know if they can drive now. And if the doctor won't say that, then sometimes they won't allow that. Do you have different experiences?
Yeah, I would just say that I've also had that experience, but I've also had the experience where the court is like, well, that's fine. They still have to go to DMV and take all the driving tests, so
Right.
it's not up to me. If they can't pass, they can't pass, but I'm not going to suspend it at this point.
Okay.
And as Jen said, if it's suspended, you can go back later once you have some evidence that they now have the cognition and ability to try to take the test and get it reinstated.
Okay, thanks.
So now you're getting, so sometimes it depends on your judge too. So these are the basics, your ongoing responsibilities. You have to notify people if the incapacitated person passes away. You have to keep the court apprised of your address as the guardian and their address, because they will mail you things like a notice of your annual report. And if they get that return, then they do angry things like issue orders to show cause because you haven't fulfilled your duties. You don't want to be on the end of that. And then obviously file your annual report. A guardian does not manage the person's money, except for the guardian at Social Security is normally the representative payee. And that is outside of any conservatorship statute because you account to Social Security. So in Arizona, again, when you read online, you'll see like conservatees, and some states mix it all together and there's a guardian of the estate. In Arizona, they're separate. Guardianship is over the person, conservatorship is over money. You do not need a conservatorship if the person has no money. That's an important distinction. Don't do it just in case because you have to account, you have to do budgets, you have to do inventories. You don't have any money, you have nothing to do, and then it's just gonna get messy. So, conservatorship, the whole thing looks so weird. Is a court procedure for someone which you have to manage their money. So let's say you're getting guardian, so the process is the same for, you know, your mom who's 85 who has dementia as it is for the child turning 18. So mom who's 85 has dementia probably has some money and assets and is going to need someone to manage her finances. And if she didn't have a financial power of attorney or if it's not in trust, then you may need to be her conservator. That's really what you're looking at. If there's less than $10,000, you're not going to need it. Thank you for having me on this part. Any questions before we end? Yes.
Jurisdiction. My child lives with his mother in Alaska. When he finishes school, he's going to come be with me, and we're going to do this process. Is there like a 6-month jurisdictional wait?
So that's a great question, asking what is the jurisdiction. So jurisdiction is typically where the person is residing. In the statutes, there's nothing that says how long you have to be in Arizona. Okay. I've done guardianships for people who have been here for weeks because they needed it. So now, the person in the other state may have a jurisdictional argument that says the better forum for jurisdiction, right? Because the person had been there longer. That fight sometimes happens as well. But Arizona doesn't have like a magic, you have to be here. Each section is different. So for example, for divorce, it's 90 days.
Can I start this at the 17-year, 6-month mark with him still living in Alaska or no?
No, I wouldn't. I think you're gonna get kicked out because the person's not here.
Okay.
Any thoughts on that, Emily? Right, okay, good point. Yeah, nobody can see them.
Right.
The court can't see them, the court investigator can't see them, court appointed counsel can't see them, so no, I think the person has to be here, but how long? If they need a guardian, they need a guardian.
Sure. Thank you.
All right, well, on to, go ahead.
I just want to make sure that between full guardianship and limited guardianship, the only factor is the driving?
Oh, so the question was between full guardianship and limited guardianship is the only factor driving. No, the guardianship can be limited in a lot of ways. Whatever you can carve out that the person can still do, then that you can limit the guardianship to that extent.
And can you, as the potential guardian, you can work with, say, your child or whatever to determine what those are?
Right, so the question was, can you work with the child or whoever you're going to be, the incapacitated person to determine what's going to be limited? The answer is yes. keep in mind that the guardian still has the obligation to listen to the incapacitated person, to carry out their wishes to the greatest extent that they can possible. If you have interest in what guardianship standards look like, the National Guardianship Association has the standards that are listed out. Some of them are for professionals, you'll see that, but they are also for family members, lay individuals, as to what that looks like. And you'll see a very, very strong mandate that the guardian needs to carry out that person's wishes as best that they can and to listen to them. So it's not like you become guardian and you're like, I'm not listening to you anymore. Well, then you're not meeting your duties. You just don't want to talk about money, right?
Here's my concern. If you have a guardianship for a young person, and okay, you say, oh gee, this guy could drive, he could drive back and forth to school or job or something that he's going to do. Suppose there's an accident, who's responsible?
So that's a great question. So if your incapacitated person for whom you are a guardian is driving, who's responsible for that liability? Presumably that person, because they were authorized to drive, would be insured, I hope. A guardian is not legally responsible for the acts of their ward, what they're called in the statute, the incapacitated person over whom they are guardian, unless they behave negligently. So if your ward is driving, but you don't have the authority from the court for that ward to be driving, you gave them the keys, well, then you've acted negligently and you may be responsible. But if the person has the authority to drive, they should have the authority to be able to become insured. And it would be, you know, their insurance company that would be responsible. Yeah. You're not going to be able to avoid special needs trust forever.
No. It comes to another question because, like in that case, I've got a kiddo who drives. They are insured. So when we have to, like, if we decide to do this in guardianship, I just want to make sure I thoroughly understand this. He will then have to re-ascertain a driver's license.
No. So the person's currently driving, and you want to petition for a limited guardianship because maybe there's some other executive function or something else that's going on where they need some assistance.
That's exactly.
Right. I have a child with a traumatic brain injury. I'm just taking a guess. So I understand. So then the answer is no. You don't have to reapply. In that initial application, the doctor could say, I'm aware this person's driving. I think they have the capacity to drive. They need assistance in these areas. And then the person could, their license doesn't have to be suspended.
They just all know you're the better speaker than I am, so I didn't want to let you go. But now you're stuck with me. And I wanted to follow up on the question you had asked in the back about financial power of attorney. So Jennifer was talking about conservatorship. So if you are the conservator for a person and then they go out and contract for whatever, they don't have access to money. So they can contract to have some subscription or buy a car or whatever it might be, but you're not on the hook to pay the bill and they don't have any funds. So that's sort of the difference between the financial power of attorney and the conservatorship. Conservatorship is court ordered, you're in control, they are not. Financial power of attorney, you're added on to help them make decisions, but they aren't removed from making those decisions. So I don't know if that helps to answer your question.
I'm looking at getting out of there.
That's fair. Did that sort of answer your question?
You can go back if you want.
Yeah, it did. I mean, couldn't you kind of accomplish the same thing with the power of attorney if they aren't going to have a lot of money anyway, or the only money, you know, in the foreseeable future for my child, the only money he's going to have is coming through me, so I'm not probably going to fund a huge bank account for him, because why would I do that? But
yeah, so
does that make sense?
So sort of go, yes. So to go back to the beginning though, people who are under guardianship or conservatorship don't have the capacity to do powers of attorney. So we're typically only doing these proceedings for people who are not able to make those choices for themselves. So although you could have a power of attorney and then the bad thing happens and now that agent needs to make all the decisions for you. So yes, as the presentation started, powers of attorney are the least restrictive way to help somebody help manage whatever, healthcare decisions, or financial decisions. If you can avoid the court proceeding, that's great. And if they don't have any money and you're the healthcare agent, there's not very much, or the financial power of attorney, there's not much they can do. They don't have any money to go out and buy those things. So they sign up for something they can't afford. That's like any of us signing up for something you can't afford. You know,
Right.
Can't give blood for a turnip, even though it looks like blood. All right, so I'm going to talk about special needs trust, just a little tiny bit about SSI, and then I'm going to talk about the ABLE Act, which hopefully most people know about. Please, just like with Jennifer, interrupt me with whatever questions. I always feel like Jennifer got the easy end of this because guardianship is something that people sort of understand. It feels more like something you can put your arms around, and special needs trust, people are like, I have no idea what she said. I've had people who have come to hear me speak over and over and over again, and then they come for a consultation, and I'm like, but I told you everything about special needs trust, and they're like, yeah, I have no idea what you're talking about. So every time I try to do this, I try to think of some different, unique way to present the information. I am going to hope that this, on probably my 100th presentation, maybe I'll get it right this time. But ask questions, because I probably won't. So do what you can to help me. So I think most of you understand SSI and Alltex funded, DDD funded through Alltex it's a needs-based program. So there's a limit on how much you can have in assets and how much you can have in terms of income in order to qualify for the benefit. So for the asset test, you can't have more than $2,000 of money in that person's name and still qualify for SSI and or Alltex once they're an adult, even if they're still on DDD benefits. Hopefully everybody understands that part of it. So the issue with the special needs trust is, what do we do in order to allow that person to have more than $2,000? Or if they inherited money and now they're over the $2,000 limit. You pass away and they're going to be over the $2,000 limit. They get in a car accident and now they're over the $2,000 limit from the settlement proceeds. So the special needs trust is this magical thing that's in federal law that allows us to put money into a special kind of a trust and have everything in that trust not count. So you could have a special needs trust with $10 billion in it, and that person can still qualify for SSI and Alltex. Now, if you had $10 billion, you probably don't want to be on government benefits because you can probably afford better services, but I just give you the example that it's not the amount of money that matters. It's, is it an appropriate trust that keeps those assets from being counted? You can have a house in a special needs trust. It doesn't just have to be cash. It doesn't just have to be investments. So you can have all kinds of different assets. And the point of the special needs trust is to have the extra money to pay for the things that those government benefit programs don't pay for. It's your slush fund, for lack of a better description. So a special needs trust works like every other trust. Oh, can we go back one? It's so weird. There's this screen up here, and you'd think you could see your presentation so you'd know where you are, but it doesn't have anything to do with your presentation. So anyway, there we go. So special needs trusts work like all other trusts in terms of their basics. That is, somebody has to put the money into the trust. Somebody is the beneficiary of the trust, the one who gets to use the money, or it's for their benefit that the money is being used, and to have a trustee. So the trustee is the one who manages the money. Yes, sir?
Can a special needs trust contain other trusts?
You can have a special needs trust, so that's, I was going to get there. We have two different, let me get there,
Okay.
and then I can answer that question, because otherwise it'll be even more confusing than it already is. So the purpose of the trust, just like everything else that you do for your kids, is to help them to be as independent as they can, to, if they can get a job, be able to work, and to be able to have some extras and improve their quality of life. So kind of what makes special needs trusts special, you can go on to the next one, is that the trustee has all the discretion to make the distributions. That is, that they don't say that the beneficiary will get $1,000 a month, or that the beneficiary will receive half of the money in the trust when they're 25 and the other half when they're 30. Or that the trust doesn't say that they get all the income and the principal as they need it for their health, education, maintenance, and support. Those kinds of things are very typical when we have non-incapacitated beneficiaries, when we have beneficiaries who are not on needs-based benefits. What makes the special needs trust special is only the trustee gets to determine what the distributions are. The beneficiary can plead and beg and cajole and do whatever they want, but only the trustee is going to make that determination. We have no mandatory distributions coming out of the trust. So the source of the money that can go into the trust, it can come from a whole variety of places, right? So it could be, as I said, a settlement from a personal injury or a wrongful death claim. It could be from an inheritance. Grandma dies and says that her estate is going to go wherever. It can be from an inheritance where there was no will, and these are just the people who are supposed to receive the money. It can be a gift. It could be that mom and dad bought some savings bonds for the child when they were first born, or grandma and grandpa did. And now there's money, and we have to figure out what to do with it if those funds are going to exceed that $2,000 limit. So if the money belongs to the beneficiary, the person who's on benefits, then we call those first party special needs trusts. You know, we have 26 letters of the alphabet, as I recall from elementary school. I don't know how many words we have in the English language. Why we have to say things are called the same thing and not come up with some different words, I don't know. Medicare and Medicaid, seriously, we couldn't call them things that are different so people wouldn't get confused. We should have third-party special needs trusts should have their own total name. And first-party special needs should have a totally different name, but they don't. So you have to understand what the differences are. So our first-party special needs trust is money that is owned by the person who is incapacitated and on SSI or All-Tex DDD benefits. So if I am on DDD benefits and I get hit by a car and I get $100,000 of a settlement, it is my money. It has to go into a first-party special needs trust. I can't just give it to my mom. I can't just give it to my brother. That will result typically in transfer penalties for having given the money away that I was entitled to. So first-party money is, it's my money. If grandma dies and she didn't set up a trust for me and it comes to me directly and I'm on DDD or get SSI, that's first-party money. It goes into a first-party special needs trust. So just to broaden your scope, we not only have first-party special needs trusts and third-party special needs trusts, we have pooled trusts that are special needs trusts. These are all run by charities, nonprofit agencies. They can either be first or third-party, depending on the source of the money. But this is typically an inexpensive way to get a professional trustee who's in charge of making sure that they make all the correct reporting and that they only distribute money that's appropriate to be distributed. We have 3 pooled trusts that operate in Arizona. Again, they have to be a charity in order to qualify for the exception. So we have one that's called Secured Futures. We have a pooled trust in town that's called Plan of Arizona. And then we have CPT Institute. They're out of California, but they operate in Arizona. So they are dealing with a whole bunch of people who are similarly situated, so they might have $10 million worth of money, but your beneficiary's money is all accounted for separately. We don't take the person with more money and make payments for your beneficiary, so it doesn't work that way. If you started off with no money, you still have no money. But they are managing it as a pool, so there are efficiencies there, and you get a professional trustee for much less money than it would cost to use a licensed fiduciary or a corporate entity. So if it's a smaller amount of money, $100,000, $50,000, you might want to look at a pooled trust, which will be a less expensive option to still manage the money correctly. For all first-party trusts, whether it's in the pool or as a separate first-party special needs trust, the state Medicaid agencies that provided services are going to get paid back for the services provided. They don't get more, so if your person dies, and they only get paid back at death. I did a presentation and the person came up to me and said, I just got the settlement money for my child, I put it in the trust, now I have to pay it to Medicaid? So, no, it's only when your beneficiary dies. So if you had $1 million in a first-party special needs trust, they die and there's $50,000 left and their Medicaid bill is $10 million, well, they're only going to get the $50,000. They're not going after anybody else to get the rest of the money. And this is only true for first-party trusts. Third-party trusts that we're going to talk about for estate planning do not have any requirement of a payback to the state Medicaid agency. But all first-party trusts do. That's the reason that we're allowed to do them, is the state is basically saying, we'll pay for services now because you have all this money over here that you could pay for your own services. We'll pay for the services, but you agree to pay us back when the person dies if there's any money left. So once the person dies, no more distributions. When I mean no more, I mean no more. You cannot pay for the funeral or the cremation without approval by the state agency. So typically you always want to pay for those services before they pass away with the money. And again, this is only first-party trusts, not the third party that we're going to talk about. So third-party trusts, I'm not going to ask for a show of hands, but this is something you do with your attorney usually as part of your own estate planning. To say, when I die, the money for my disabled person is going to go into a third-party special needs trust, and then the trustee is going to have discretion over those funds. You can say whoever you want to be the beneficiary of that kind of a trust. And you get some more flexibility on the distributions because we have a statute for first-party trusts about exactly what the money can be used for. Although it's, again, pretty typically, as long as it's used for that beneficiary, it's fine. To answer your question up front, you can have a third-party special needs trust with lots of different beneficiaries. So I could have a third-party special needs trust for both of my autistic kids, if I had kids. I don't have any kids autistic otherwise. But if I had 2 children with autism, I could have one third-party special needs trust for both kids. And whatever their needs are comes out of the pot. We don't have to divide it 2 and 2. We could have a third-party special needs trust that says when that beneficiary dies, then it goes to their siblings outright. We don't have to have the state as the recovery agent at the end of the person's lifetime. First-party special needs trust, we're going to have one trust per beneficiary, no sub-trust, nothing else is happening there except for that beneficiary is going to be taken care of. So as I started to say, the distributions from third-party trusts are pretty broad, again, as long as it benefits the beneficiary, much stricter distribution requirements from the first-party trust. Remember also that our distributions, it looks much prettier on my thing. The distributions from a trust for common expenses, the beneficiary of that trust can only pay their proportionate share of the expense. If everybody goes out to dinner, the trustee does not pay for everybody's dinner. The trustee pays for that beneficiary's dinner. If you go on vacation and your beneficiary couldn't travel by themselves, well then the trust can pay for that beneficiary's plane ticket, hotel, food, tickets, blah, 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 and a companion to go with the beneficiary because they can't travel by themselves. But the trust isn't going to send everybody to Disneyland. You and your spouse and your other children and your grandparents and everybody else. That's not the way the trust works. We're using it for the benefit of that beneficiary. Sort of makes sense, I hope? So again, from a third-party special needs trust, pretty much anything that's going to benefit that person. Just because your lawyer did the special needs trust, doesn't matter how fabulous it is and whether it should be on gold leaf paper or not, the lawyer doesn't get to decide if it meets all the requirements for eligibility to be a non-counted resource. As soon as there is 1 penny in that trust that is titled to the trust, so instead of it saying Emily Kyle, it's titled to the Emily Kyle Special Needs Trust, as soon as 1 penny is in there, you must disclose the trust and any and all assets titled to the trust to all of the agencies that provide services to your loved one. So oftentimes clients come in to see me and they say, we were talking about something else, and they say, oh yeah, he's got money over here that his grandparents left him and that's in a trust over here. First or third party doesn't matter. And I just say casually, did you get that reported over to SSI when they were approved and off to DDD? And they're like, why would I do that? It's not a counted resource. That's what my lawyer told me. Well, it shouldn't be a counted resource, but when you sign up for them, whether you realize it or not, when you sign on the dotted line, you're saying, I agree to tell you about any change in my financial circumstances and about any and all assets that are there for me or for my benefit. So So if there's a special needs trust for your loved one, if it's just drafted, you know, you did it at the lawyer's office, it's gonna get funded, that is when you pass away, money's gonna be available for your kid, you don't have to report anything. It doesn't have any money in it. There's nothing to report. Who cares if it's countable or not countable? It doesn't have anything. But as soon as it has a penny in it, it must be reported to the agencies. That means that you have to give them a copy of the whole trust. You can't just give them like the 3 pages if it's a sub-trust under your irrevocable trust. You can't just give them the 1 page of the will that talks about that there is a special needs trust. You have to give them all the pages of the trust and then copies of any and all documents that show titling into the trust. You have to let them know all kinds of other changes, kind of similar to what Jennifer was talking about for guardianship. If there's a move, if they get married, if there's some other financial or other change, you have to let the agencies know about that because it may impact their benefits. An unmarried beneficiary is treated differently for SSI than a married beneficiary. So they have to know all of those things. First party trust, you can only put money in, fund the first party trust. That's the one for lawsuits and inheritances with a bad estate plan when they're under 65. So if you have a 70-year-old person who gets hit by a bus and they're on all tax benefits, you can't put the money in a special needs trust, in a first party special needs trust. That's a transfer. I don't make up the rules. I swear to God, I could never have thought any of these things up, but that's the way the rules work. You can fund a third party trust anytime you want. You die and your child with autism is now 70, the money can go into a trust for them because that's a third party trust. The state doesn't have any right to recover against those monies. So don't get confused between the two animals. Social Security is going to review the trust. They're going to make sure it meets all their criteria. They're going to want to know what's the source of the funds and review it. Now, the really bad thing about Social Security is when you send a trust in, the only time you know that it's a problem is if they send you a letter back that says it's a problem. If it's good, you will never hear from them. There's no cover letter that they send out that says, wonderful job, not counted as a resource. As long as the person continues to stay on benefits, you're probably okay. However, there's also not really a statute of limitations. So it might be a year later that Social Security sends you the letter that says, we reviewed your trust and think there's a problem with it. I would say that they are really better in one way. They're better about sending out the denial letters. Unfortunately, most of the time the denial letter is wrong. So then you have to convince them that they were wrong and that it shouldn't be a counted resource. So if you get a letter that ever kicks your loved one off of benefits, you have really short time frames to do your request for reconsideration. So the most important thing is to respond or get an attorney to respond as quickly as possible so that benefits can stay in place until you can have your appeal. Because to do an appeal from Social Security, the last one that I just had a hearing on, it was 2 years from the date that they sent the denial before I was in front of the administrative law judge. And I walked in and she did her little, this is our hearing, blah, blah, blah. And she looked at me and she said, I just want to be clear. This was a denial for SSI benefits because there was a trust. And I said, yep. And she said, well, I looked at the trust and I think it meets all the criteria. And I said, yes, it does. And she said, so I should approve the trust. And I said, yes, you should. And that was my hearing. And then 6 months later, I got my letter saying that it was all fine. So this poor gentleman for 2.5 years didn't have any SSI. He's now getting a check for whatever, $30,000 for all the years he should have gotten benefits, but it is a long process. If you're on SSI and then you get the denial letter, if you get your request for appeal in fast enough, they'll keep paying you until the outcome of your hearing. So at least you don't lose the benefits in the meantime. But if you haven't been approved yet, they're not going to pay you till the ALJ says everything's okay. So just be conscientious. The joy of Altex when you send the trust in, though, is they're really fast, and they'll tell you, this is a problem, it should say this instead. Okay, I can do an amendment. So it's just SSI that can be problematic. So the trustee is just like a trustee of any other trust, is in charge of managing the fund, making the distributions, usually making the reports and filing whatever tax returns are required. So you want to make sure you have somebody who's on top of things, who's organized, who's trustworthy, who's ethical, and who understands the rules. Because if they make a distribution that they should not have made, it can make the entire trust void and not a special needs trust anymore. So you want to have somebody who knows what the heck they're doing. So the, oh, it is updated, excellent. So when somebody's on SSI, you probably understand that if there are distributions from some other source for food and shelter expenses, it will reduce the SSI payment. So for almost every adult child who's on SSI and who lives at home with you, they're getting slightly less than the $750 max because you're providing all their food and shelter needs. So they get, you know, about $250 off of their regular SSI of the $750. When the trust is paying for food and shelter, you have the same thing happens. The idea of SSI is it's supposed to pay for food and shelter. So if somebody else is making that payment, then there's a reduction of that maximum $750. Don't fret about it. It doesn't, if the rent payment would be $1,000, they don't deduct SSI by $1,000. They can only deduct it by 1/3 of the total $750 to get to where the number is. So, you know, there's no reason to freak out about it, I guess would be my point. And usually I tell people, rather than dealing with telling SSI that you're gonna collect rent from your kid, just get them on benefits first, and then we can talk about how to raise them up to get the maximum, instead of starting with the fight of it shouldn't be reduced and then having to have that whole discussion. Yes?
I'm pretty new to this. How do you get your kid on benefits? And I know that just, where should I go?
So for SSI benefits, you go to Social Security. We have a handout on the back with a checklist of all the documents you want to bring and the number you should call. You should make an appointment. Don't just show up, because you want to not spend your entire life at the Social Security office. So you should make an appointment, and then in some of the offices you just talk to the person right at the counter, and in some of the offices they bring you in the back and you have some semblance of privacy, although not much because everybody's in a cubicle. For some of the kids where there is a presumed disability, somebody with Down syndrome, you're going to get your SSI much faster. Autism, everybody understands, is like that. So it just depends sometimes on when they review the medical records that they'll get from the physicians and review to determine whether they think that the child can be gainfully employed or not. They may send that person to their vocational rehab person and see whether they think that they can get on benefits, you know, all those things. We have sort of an expert, Susan Marks is here, who does some, yes, she does appeal sometimes on the medical side. So useful information, and again, it just depends.
You can
Yes.
apply online now too.
For SSI? Not just for SSDI? Oh, well,
I heard
there you
they're working on that. Is that up?
Yeah. they
Wow.
go. Oh, great.
Awesome.
What do you do in those instances where you have to have your child sign, or they want the child to sign, and of course, like with my daughter, she can't sign. But I've also heard that you could do it, if you could just do a hand over hand, just mark it, because as long as they can at least mark it, then I know that a friend of mine tried to get SSI and he said, oh, I just kind of used his hand. He couldn't have done it on his own, but I used it just to get the signature. Have you ever heard of anything like this?
So if you are the guardian for the person, you bring your guardianship letters with you if you're doing an in-person application, and I've never had Social Security or any family tell me that that was not sufficient, even though they're a federal agency and they don't have to listen to our state court orders. If you can apply online now, then there would be no signature other than you click the box that says, yes, I signed. So I haven't had that as a problem. Sometimes when I think I'm not sure whether they're going to approve them medically, but the child has some behavior issues, I just tell them to bring the kid with them. If you would like to see what happens and you don't think that this person can be gainfully employed, well, you can watch them do all of their lovely behaviors, which is going to make it very difficult for them to get a job. So it just depends. And if you do an in-person interview, you can expect to be there for about 4 hours.
Is there an option during guardianship to maybe not have your child there? Just because, what if you schedule your appointment and then they're sick that day for some reason, you don't want to miss your appointment, can you still go?
So on guardianship?
Yeah.
Yeah, so your child doesn't have to go to the hearing. If you, court appointed, if the child wants to be at the hearing, they must be at the hearing. But if the child doesn't want to be there, doesn't care, is sick, doesn't want to miss school, whatever those things are, as long as court-appointed counsel isn't going to object to that person not being there. Because if your child wants to object to the guardianship, your child needs to be there. And if something comes up, there's an emergency, we can vacate the hearing and get it reset. So if there's a family emergency or something else happens, we can just tell the court, we had an emergency, we need a different date. So let me get through ABLE in the last couple of minutes that we have. So ABLE accounts, until recently, were not in Arizona, but we have them now. So an ABLE account can be set up by, for or by a beneficiary who is disabled prior to age 26. So if you have a traumatic brain injury at 50, under current law, we can't do an ABLE account. ABLE accounts are kind of like the first party special needs trust. So money in the account, there's a payback requirement at the death of the beneficiary, and the money is there for the beneficiary's use. The nice thing about the ABLE account in Arizona is that you can get a debit card. So, you know, if they want to go get their haircut, they want to go out to lunch with their friends, they have a debit card that looks just like any other credit card, and they can have that sense of independence. So it's kind of a nice way to have the kids who are able to sort of manage money without having cash, manage those funds, and it doesn't impact their SSI benefits, and it doesn't impact their Altex benefits. Yes, ma'am?
But does the owner of the ABLE account set up in Arizona have to live in Arizona?
So I believe that Arizona is only for Arizona residents. So if the person lives somewhere else, they would have to join like the Ohio program, where you can be a resident of any state.
Is Ohio the only one that does that for?
No, lots of states will allow you. If you go on the ARC's website, they have a list and a description of all of the ABLE accounts throughout the country, along with, you know, any information about them, whether they have debit cards or don't have debit cards, whether you have to be a resident or don't have to be a resident. Most of the states, there's no residency requirement, but I believe that Arizona's is.
Yeah, why?
I don't know, because it's Arizona.
And if you have an adult child and they have a debit card, don't they have to keep track of whether they're spending this on things that are allowed or not? How does that work?
So the question is, if they have a debit card from their ABLE account, do they have to keep track? So yes, they should keep receipts for what they're doing, but anything, it has to be for what they call a qualified disability expense, which in reality is anything that benefits the beneficiary. So if it's helpful for them to have a phone, then that's a qualified disability expense. It can pay for food, it can pay for housing. It can pay, they can't give the money as a gift, but it's not cash.
So do they have to file a report on that?
So the question is, they have to file a report on that. I just had a client meeting this morning who asked exactly the same question and was looking at me like, how is that possible? So the answer is no, there's nobody to report to. So at some point, the Medicaid agency could ask for an accounting to make sure the funds, I suppose, weren't misused. There's no accounting form that there is. So we just tell people, keep your receipts, but it's pretty loose. And you can only contribute up to $15,000 a calendar year, which is tied to the gift tax exclusion. As long as the account doesn't exceed $100,000, they don't lose SSI or their DDD Altex benefits. If it goes over $100,000, their SSI is suspended, not terminated, until the account goes back down under $100,000. So it takes some time to get there though, $15,000 a year, and maybe there's some growth because you can invest the money before you get to $100,000. But you never lose your Altex DDD benefits regardless of how much money is in that account. Yes?
So I want to go back to establish an account through Arizona. So say like I establish an account, legal account for my son. He lives here for 2 years. So I mean, if he moved out of state, then he'd have to reset up another able account.
So the question is, if the child moves and they set up an account in a state where they had to be a resident, do I have to set up a new account? My understanding is the answer is no. Once it's established, it's established. You only got one ABLE account per beneficiary. So in order to open that other account, we have to make sure that the money can be transferred from account to account. And if you're divorced, your ex can't open an account and you open an account. One ABLE account per beneficiary. Everything is online. I get calls all the time for, I'm at Chase Bank and they don't know anything about ABLE accounts. They're only online. Only. They're through DES. az-able.com is where you set them up. You kind of go through a series of questions and answer those questions to make sure the person's disabled, was disabled prior to age 26, where do they live, all that sort of stuff. If your kid's not sophisticated enough to manage the money, that doesn't mean you can't have an ABLE account. And we typically tell people if there's like an inheritance and some of it's going to go into the pooled special needs trust, but mom and dad want to have some control over the money, we can ask the court to put some of it, authorize the ABLE account, and then the rest of it in the first party special needs trust, because we have the same payback requirements regardless of where we are. So I talked about that. I talked about the caps in terms of how much money there can be. We have some of the states listed, but again, if you go to the ARC's website, it will tell you all of the ones that exist. Yes, one last question.
Basic question. So is the ABLE account just basically giving the adult child a bank account so that, and then like I'm putting money into it so that it doesn't affect the SSI?
Right, so the money in the ABLE account does not affect the SSI. It was a way, the purpose of the statute was to allow folks who are on public benefits to save money. Because since you can only have $2,000, there's no other way for that beneficiary to save anything.
Right.
I probably wouldn't recommend as a parent that you just put money in it because there's the payback to the state if the child dies. But if you have a child who you want to be have some responsibility over some money, feel like they have something.
Like buy a video game with a debit card, you know, just so he learns the transaction.
Exactly. So that would be a way that you could help that child to feel more independent, that there's funds available that they can do with what they want. As long as they buy things that are for them, then they're perfectly fine.
Okay.
Yes.
We have an ABLE account and the card company is separate from the bank. And the card company, it takes a while to transfer the money just so they know to the card. And then there are settings within the card that you can play with if you don't want them, which are certain things. But I noticed our son likes Buffalo Wild Wings. But I thought, okay, use your card, you know. And there are fees, and I've got to check because we have some of it spread out in the Vanguard investments that are within the ABLE account. And I would tend to use it more like a savings account, I guess, than maybe his paycheck or something going there, than like we do a checking account or a debit account, because that card account is pretty restricted. He could go, he tried to purchase at a burger place one time that denied it, or, you know, and he had no in there, or just like Buffalo Wild Wings because it has a bar. I guess, because they tried it at each place.
Yeah, because it's supposed to be able to be used for food, so it's too bad that it's not.
We may have to, through the settings,
tweak which things you can use it at.
Just so FYI,
Yeah.
my checking account.
Yeah,
And it depends on the card company, which part of the bank rate. Iowa, is it that first, but we have access to the articles about and that which, and that's what we have. Because there may be others who just want to check in the fees and, you know, how their card works and.
Yeah, and so my understanding is if you just leave it in cash and it's not invested, I don't think there's supposed to be any fees associated with it.
That's what I was going to check, because I noticed there was a 350 here and a 350 there, it might have come out of all those.
Yeah, so just if you decide to do the investments through Vanguard or whatnot. So I don't want to run over, oh yes, go ahead, I'm sorry.
I'm sorry. Our son just got a job in California. California doesn't have ABLE accounts yet. We haven't set up one here yet because he's not a resident here now. We were thinking he could take his salary when he gets it into the checking account and he could add money himself into his ABLE account. Is that something he can do?
So is he does he get SSI benefits?
Yes.
Yeah. So you can't put the money directly into the ABLE account, but he could get his income, put it in his account, and then transfer it over to ABLE. He needs to make sure he's monthly reporting his earnings for SSI purposes. But yes, he can get the money, he can earn his money, put his paycheck in, and then move the money over to the ABLE.
As long as they're reporting to SSI.
Correct.
Do they have a system to do that?
They have a system to report monthly wages. If you go on their website, you can either do it directly through their website or there's an app to report to SSI your wages.
Thank you.
Yes. So thank you all so much for coming to speak, to listen to us speak. We know you had lots of choices, and I'm sure it's already been a long day and it's a lot of information. We have information in the back, as Jennifer said. Sign up for our newsletter. We're here to answer questions at least for a couple minutes till the next speaker starts. So thank you all. You have a difficult journey, so thank you for coming.